The Daniel Penny case ends in an acquittal, and we got lots of thoughts about it today. Stay tuned. This is attorney Andy Marcantel and attorney Brittany LaBerry from the Attorneys for Freedom Law Firm here today to discuss a very high-profile case that has captured the nation's hearts. How you doing, Brittany?
I'm doing well. How about you?
That was kind of an overstatement. I don't know if it's really captured the nation's hearts, but it's certainly captured their attention. And for some reason, it's become an extremely controversial case. Some people saying that Daniel Penny was a hero and acted as a good Samaritan to protect innocent people on the subway. Other people villainizing him, even going so far as to saying that this was a race-motivated attack on a weak and vulnerable person. So for whatever reason, this has become a very controversial case, when frankly, I think it's pretty straightforward.
Yeah, I think people have very strong personal views on this case, no matter which side you lean. I'm excited to talk about the legal analysis, right? Like we've seen in the news, a lot of it's focused on race and stuff like that. But we're going to break it down and talk about what happened and the law behind it and what the jurors decided that day.
Yeah, our job here is actually pretty easy because we're attorneys. We're not social commentators. We might have a little bit to say about some of the things that were thrown around insofar as they relate to our legal analysis. But it's pretty cut and dry what we're here to do today, which is take a look at what the evidence shows, what the law says, what the legal standards are, what's relevant to that analysis, and what's irrelevant to that analysis. We'll try to flag that as we go, and give our thoughts on the procedure that happened in court, the deliberations, the kind of interesting moves made by the judge towards the end of the case, and ultimately the verdict. So it should be pretty straightforward.
All right, let's dive in. So let's set the stage of what actually happened. I'm sure everybody knows the gist, but let's just break it down before we jump into the law. So what happened was on May 1st, 2023, Daniel Penny got onto the subway in New York City. Jordan Neely also got onto the subway. Jordan Neely was acting irrational, crazy, saying, I don't care if I go back to Rikers Island. I don't care if I die today. Somebody's going to die today. I need food. Acting absolutely crazy, scaring other individuals, as witnesses say. Daniel Penny stepped up because what the witnesses said was that as he's making all these crazy statements, he then lunges at a woman, and Daniel Penny steps in and takes him down and puts him in a chokehold. Now, we'll jump into what witnesses say, but witnesses say he didn't use too strong of a chokehold, just enough to kind of restrain him. Now, people were calling 911. Police were arriving. It seemed on the body-worn camera they were hustling. They were trying to get there, but from what witnesses said, it took them a long time. Daniel Penny continued to hold him down. Two other individuals helped him, and eventually Jordan Neely did lose his life. After that, Daniel Penny was arrested and interviewed. He did talk to police. He did not invoke his Fifth Amendment rights.
He waived his Fifth Amendment rights and had a chat with the cops.
Yep. There were a bunch of witness statements that we also got to review. Now, we haven't seen all of them, I'm sure, because most of them aren't public since we aren't the attorneys on record, but we did get to see a lot of the witness statements that we'll talk about today.
Yeah, and it was a 6-minute approximately long chokehold. There were a couple of other people that were kind of assisting Daniel Penny restrain the guy, and there were some people kind of standing over, available to him, arguably, to help restrain Mr. Neely if he was able to break free of the chokehold. I think it's important that a lot of witnesses said that he kind of pried the door open when he got onto the subway. Neely pried the door open, threw down his jacket and said, somebody's going to die today. I'm not scared to go back to prison. I want some food. I'm hungry, and I'm willing to kill people for it, essentially. There is a little bit of discrepancy about some of the statements, though quite a few of it was captured on video. People started pulling out cell phones and recording different parts of the interaction. And we actually have quite complete videos, all things considered, that it was just captured by civilians on cell phones. We get it from a couple of different angles. And there are some statements on there, we might consider some of them exculpatory, things that tend to help the defense in the case, and some inculpatory, some things that the prosecutor would argue show that there's some guilt here. For example, there's at least a couple of statements on some of the videos of bystanders saying, hey man, like you need to let go of his neck. He's dying. He's in trouble. You need to ease up on him a little bit. While other people seem to be encouraging him to be restrained. The cops show up. They interview people afterwards. It's important to note here the timing. They take Mr. Penny away from the subway at that point before he knows that Mr. Neely has died. And so you got to keep that in mind, that when he is back at the police station giving his interview of the incident and waives his right to an attorney and chooses to speak to the cops, he doesn't know that Mr. Neely has already expired back at the scene. And you can kind of see that in his timbre and tone and everything like that. Of course, later this was used by the prosecutor to imply heartlessness or something like that. Oh, he just killed a man and he's just chatting it up with the cops all casually and having a couple of laughs with the cops talking about, their time in the military and things like that. Look how heartless the guy is. One of the many reasons, and we'll talk about it a little bit more in depth, one of the many reasons you don't talk to the police without an attorney, and you should just shut up, especially after this type of an incident.
Absolutely. And I think it's good to highlight, too, is that Mr. Neely was still moving around during this 6-minute interaction for most of the time. So the video that we saw did say that he had his last voluntary movement, and then 51 seconds later is when Mr. Penny, Daniel Penny, released. So he was moving throughout this interaction.
Absolutely. So he was released that day, Mr. Penny, but very shortly thereafter, he was arrested and indicted, and they brought charges against him. The prosecutor, Alvin Bragg's office, who seems to be making a lot of headlines these days because of some of the interesting prosecutions that he's been the spearhead of, but we'll leave that aside. His office chose to bring some charges, and the charges under New York law were manslaughter in the second degree and negligent homicide.
Yes, and we have those statutes today that we can read. So manslaughter in the second degree was the more serious charge, and that states in New York law, the person is guilty of manslaughter in the second degree when he recklessly causes the death of another person.
First, I want to say how sexist this statute's language is. He or she or them, please. He recklessly causes the death of another person. A couple of things about that. The standard here, what we call the mens rea or mental state, is important to discuss between these two statutes. This one requires recklessness, and recklessness is a willful disregard of a known risk. In other words, in order to prove this, they'd have to show that Mr. Penny knew that there was a very high probability that Mr. Neely was going to die if he puts him in this chokehold and chose to do it anyway. That's the recklessness standard. And importantly here, if he's convicted of this under New York law, he's going to prison, and he's going to prison up to 15 years.
And then the criminally negligent homicide statute in New York states a person is guilty of criminally negligent homicide when, with criminal negligence, he causes the death of another person.
Yes, so back to the mens rea discussion here. Negligence is not a wanton disregard of a known risk. Rather, it's kind of a mistake. It's an oopsie. It's, you should have known that this was going to be a risk to his life. You didn't know, but you should have known, and so therefore we're going to hold you negligent. The mens rea, the mental state required, is that oopsie, where any reasonable person would have known that holding him in this type of a chokehold was likely to result in death, and he just kind of ignored that risk. And importantly, under New York law, if he was convicted of negligent homicide, it's actually probation eligible for Mr. Penny because he doesn't have any priors, and we'll talk about his background in a minute. But with no priors, you're actually eligible for probation under this particular statute. The judge does have the option to send you to prison on this statute, even for a first-time offender, but it's a much lower range. We're talking a maximum of 4 years.
Yes. Now, we read the statutes. Let's talk about what's irrelevant in our analysis, right? We talked about the facts of the case. Like you said, we'll talk about the interview more with Penny. We'll talk about what the witness statements say, but let's talk about what's not relevant, right? What's not relevant is anything that Mr. Penny did not know at the time, right? So it doesn't matter that Neely grew up in a foster home, although that's terrible and unfortunate, not relevant in our legal analysis. The fact that Neely's mother passed away at a young age, not relevant. The fact that he was diagnosed with schizophrenia, not relevant. The fact that he was homeless, not relevant, right? All of that does not go towards relevancy in the legal analysis. Something else on Penny's side, right? Penny's background, the fact that he was a Marine or had military experience, not relevant.
Yeah, all very good points that you make, Brittany, and this might surprise some people. because you'll see a lot of chatter around this case on both sides talking about the backgrounds of the people involved. And it seems to a layperson that this stuff should be really relevant. Take, for example, the arrest record of Mr. Neely. My understanding is the guy had been arrested 42 times, somewhere around there.
And he had an arrest warrant at the time of his death.
He had an arrest warrant at the time of his death. The year prior, he had just gotten arrested for assaulting someone on a subway. So that sounds really relevant if you're a layperson. And you might ask, why isn't any of that stuff relevant? It seems like it'd be really relevant. The reason is, all that matters at the time that Mr. Penny uses the force is what he knows in his mind. All of this stuff, by the way, would become extremely relevant if Mr. Penny knew about this stuff. But Mr. Penny didn't know who Mr. Neely was. He had no experience, no encounters with Mr. Neely before, and so he was judging based on what he saw at the time. And this is the legal standard. It's a reasonable person with similar knowledge and experience as Mr. Penny in his situation. Did they use appropriate amount of force in that situation? And so while all of these things about the violent background and the 42 priors and everything like that certainly serves as an explanation as to why Mr. Neely behaved the way that he did that day, it doesn't even go to any sort of legal justification for Mr. Penny.
Absolutely. Let's jump into the medical reports. Like we said, Mr. Neely did lose his life in this interaction, and the autopsy showed that the cause of death for Neely was compression of his neck. Now, I think that's interesting because the articles that we have read actually stated that the toxicology report did not come back before the medical examiner ruled the cause of death. Now, that's something that defense counsel really harped on, right, as they should have, because really they didn't know the cause of death. It was stated that he was on K2 at the time. He did have schizophrenia. Neely also had a medical condition that also could have contributed to it. So the fact that they ruled the cause of death before receiving the toxicology is super important in this case.
It's also super suspicious. It's the type of thing that gets a jury scratching their head. Hold up. So you're telling me that the coroner didn't even see the toxicology and they already concluded what the death was? Yeah, there's actually some scientific backing for that. If it's really, really obvious to a coroner what the cause of death was, then they can pretty conclusively and scientifically accurately make that type of a conclusion. But it's the type of thing that makes a jury a little bit suspicious there and says, well, hold on, this looks very biased from the get-go. They didn't wait for all of the information to come back, and the defense seized upon this point, and as you said, it was a very good tactic for them because they started throwing out all kinds of different explanations at trial for what could have caused the death. And this is really important because, as you saw in the statutes, one of the elements is that Mr. Penny actually caused the death, and so arguing he didn't actually cause the death is a real defense on the merits in this case.
Absolutely.
So as far as what the defense's strategy was, given that everything is on video, nobody is saying on either side that Mr. Penny didn't use the force that he's accused of using, right? It's all there on video. The only question is, does he have a valid justification statute under New York law in order to be able to use the amount of force that he did? And so the defense had two different statutes to choose from that they presented to the jury at trial. One was self-defense, that he put Mr. Neely in the chokehold in order to defend himself against an imminent threat. And the argument there is that the amount of force that he used was reasonably necessary to protect himself from any imminent threats. But then there was the even more prominent defense at trial, which is New York's defense of a third-party statute. And this basically says that you're allowed to use a reasonable amount of force to restrain somebody from carrying out an imminent threat of force against a third party or third parties. Now, this, of course, became the centerpiece of the defense's theory, and that's what they really harped on, that, he acted as a good Samaritan because this person was threatening imminent death or serious physical injury to numerous people on that subway that day.
So let's talk about those witness statements. It is all on body-worn camera. They, like you said before, Penny was already removed from it before before they did these witness statements, but all the witnesses were in support of Penny. The first witness is Yvette Rosario, and when police were interviewing her, she said that she looked at Neely, then he threw his sweater, he walked into the train car and said, "I had a rough day. I don't care what happens today. I don't care about going to jail. Somebody is dying today." Another witness, Deshaun Latimer, said Neely told everybody that he was looking for food and he's ready to risk it all. He basically said, "I'm ready to hurt somebody. I'm ready to go back to Rikers Island." He also said, the dude right here talking about Penny, "I don't think he did nothing wrong." Another statement that he made is that the cops took mad long to get there and that he's one of the people who called 911. Another witness, Alethea Giddings, said that Neely said he was about to hurt somebody and he did something. Neely said, "I'm willing to die. I'm willing to go to jail." Alethea also highlighted how Neely was acting. She described him as belligerent, that he was high on something. He came in scaring the living daylights out of everybody. She also described Penny's chokehold as not a hard chokehold, just enough to secure him. And the guy fought, so he kept securing him. So Alethea here, the witness, is basically saying that she didn't think Penny was using excessive force, right? She basically said, not a hard chokehold, just enough to secure him.
Yeah, this is all really important stuff for several reasons. First of all, we can assume that these people who frankly are the victims in the case, who are being threatened by Mr. Neely with death and serious physical injury and things like that, we can presume that these are reasonable people. And the jury was asked in this case to say what a reasonable person would do. And so we have the people who were actually there for the incident saying this was a reasonable use of force and we're glad that he did it.
And we were all scared and he was threatening us.
Yes, absolutely. And it was really important, too, how multiple of the witnesses developed the conduct of Mr. Neely at the time. And this is really, really important. You've heard us talk on this program before about what we might call the mere words doctrine. And this is a long-established doctrine in the law that says words alone are not enough in terms of self-defense. If somebody threatens to do something, their words alone are not enough to justify the use of force. However, as soon as you start adding action to the words, force can be justified even if they hadn't aggressed against you first physically. So, for example, saying, "I'm going to kill somebody, somebody's going to die today," and menacingly going around a subway car and maybe even lunging at somebody and throwing things down and making wild patterns with your hands, the law's going to say it's no longer mere words. Now it's accompanied by action, and that does constitute an imminent threat. And we're allowed to take people at their word. When they are sitting there saying, "Somebody's going to die today. I don't care about going to prison. I'm getting what I want today from one of you guys," and they're going around menacing and their physical conduct is accompanying that, the law does not require us to wait until they actually act on the threat. This is part of living in a civilized society, is that if you try to make some sort of a threat or disturbance like this in a public place, there's a certain amount of risk that you assume. And certainly Mr. Neely assumed the risk that day by behaving like that.
I'm just speculating here because we don't know what the jury, discussed in the deliberations, but I'm sure they really discussed the witness statements, right? Because they were firsthand witnesses. They were not involved, right? It wasn't the defendant, it wasn't the victim or the alleged victim in this case. And they probably really harped on those statements. Being from Chicago, I've had personal experiences with this, right? I mean, I have literally seen somebody be robbed at gunpoint on the L, which is like the Chicago version of the subway.
How often would you ride the L in Chicago when you lived there?
Every day, twice a day to go to law school. And so it was out of control at one point. I told my husband that if I make it out safely, I'm the luckiest girl alive.
Wow.
Because the amount of crime on these public transportations is absurd. I mean, if you don't live there, if you don't have personal experience, you don't get it, right? It's crazy how scared I was. So I actually started taking the city bus, which put so much time on my commute, but there was a city worker in the bus, right? So I felt safer and I'd sit right behind the bus driver. But I've dealt with these things. I've dealt with people coming in and making, huge threats physically, verbally. And so I, kind of empathize with these people on the train. And I'm sure that because the jury's a member of the public right close by, I'm sure the jurors also had some sort of personal experience with maybe not something this serious, but I'm sure other experiences that I'm sure also played into their thoughts about this case and their biasness as well.
Yeah, this is a super good point that you're making. I appreciate you making it because I can't relate. I've never lived in a place where I had to ride a subway or do public transportation. So I think that's an interesting thing at play here in this community in particular, that the rest of us throughout the United States who don't have this form of public transportation, we can't really relate to.
Yeah.
We can't step into their shoes as much because we haven't had those similar experiences.
It's crazy.
Yeah, but even some of the witnesses that were called during the trial said, yeah, look, we see this kind of crazy stuff on the subway all the time, but this was different. This was next level. Yes, this wasn't just your average crazy guy coming in and ranting and raving. This guy was menacing and throwing things down and flailing his arms about and kind of lunging at people. And so this wasn't your average crazy person on the subway. This was what we reasonably perceived to be an imminent threat. This guy was going to hurt somebody.
Yeah, absolutely. And after those witness statements, or I should say during those witness statements, is when Penny was taken to the precinct. And he, like we talked about earlier, did not invoke his Fifth Amendment rights and did speak with police. You want to talk about the interview?
Yes. Here we go again, guys. Another wonderful example on why you don't waive your Fifth Amendment rights and speak to the police.
And I will say that Penny was a Marine, and, I'm sure that he has respect for law enforcement. But even if you have respect for law enforcement, which you should, of course, and even if police are trying to act like your friend or act like they relate to you like they did really well in this interview, still don't talk to them,
well,
right?
That very point was used against him by the prosecutor in this case. So as is a common interrogation tactic, the police start by buttering him up a little bit. You can watch the full interview. It's been released to the public. And it starts out with some small talk and chit-chat about, hey, we were both in the armed forces, and where were you stationed, and what did you do, and what was your rank? And they get each other laughing a little bit like that. And of course, the prosecutor isolated the laugh and the nonchalantness and everything like that to say, look at this cold-blooded killer. Mere minutes after killing Jordan Neely, he's sitting there laughing and smiling and everything like that. So even things that seem like they're going to be innocent that are going to help you, even human moments between you and the police, can be extracted from that interview and used against you to your detriment. And the prosecutor certainly seized upon that. There's a reason why every criminal defense attorney tells you do not talk to the cops, even if you think it's going to help you.
And that's a great point. So if you went to our AOR conference, we had Jeffrey Hines, which is our use of force expert that we use. He's incredible. We had a panel with him, with Mark. And Jeffrey Hines used to be a police officer, and he has seen so many officer-involved shootings. And every time that an officer was involved in a shooting, they would have an interview with them, and their recollection of the events did not match the body-worn camera. And I'm not saying even if it was just small, little discrepancies, but because you're in that adrenaline state, you cannot remember, as Jeffrey Hines said, what actually happened, right? And so Jeffrey told all of our, members this story and said, this is why you don't talk to police, because police are trained, right, to shoot and trained to deal with these, stressful situations. And even they can't remember what happened during that use of force. And so if the police can't remember, certainly a civilian who is, just going about their day not expecting to use this force will remember the events exactly correct, right? And so that's another reason why. And you hear it from Jeffrey Hines, who's seen hundreds of police shootings.
Yeah, and, I tell people, because I speak to the police, and the police that I know have told me, I don't even let my kids talk to the cops. Police officers telling their own children, don't speak to the cops, there's a reason. But also, I think that the worst thing that came out of his interview wasn't even something that he said. It was something that he didn't say during the interview. This is an important point. I think, and I've been arguing for this for years, I think the Fifth Amendment needs to be rewritten a little bit to make it a little bit more clear as to what it actually says. The Fifth Amendment and the Miranda warnings are kind of interesting, because when you hear the cops pull out their Miranda card at the beginning of the interview like they did here, and they said, you understand that anything that you say can and will be used against you in a court of law. Really what it should say, what the warning should say is, everything that you say and the things that you didn't say can and will be used against you. And oftentimes when you waive your right to remain silent and you choose to engage in a little chit-chat post-incidents with the cops, if you don't have a perfect recollection and a perfect recounting of what happened because you waived your right to remain silent, the prosecutor can now talk about, well, he chose to talk to the cops, he chose to make a statement, and he never mentioned that before, and so therefore he's making it up now. And that happened in this case. Daniel Penny sits down with the cops, he gives his recollection of the incident, and he leaves out the detail about Neely lunging at that woman. He just totally either forgets it or for whatever reason doesn't mention it, and at trial brought up that, Neely was going around and lunged at a woman at some point. And so Mr. Penny thought that she was being threatened, and so that was one of the factors in deciding to restrain Mr. Neely. But because he didn't say it in that recorded interview, the state is able to seize on that and say, well, hold on. He chose to give a full statement that day, and he didn't mention anything about a woman being lunged at. He's lying. The explanation is he made it up before trial. He sat down with his lawyers and made it up before trial. It's the first time he's ever bringing it up, and it made him look like a liar. Now, I don't think Mr. Penny was lying about this at all. I don't think that he made this up after the fact. But he looks less credible because he didn't bring it up, and now the prosecutor is able to make an implication. The more likely explanation for why he didn't bring it up is he either didn't remember everything in the moment, he had just gone through an extremely stressful situation, he's now sitting in a police holding cell being interrogated by a couple of cops, and that's the worst time to make a statement that's accurate and that recounts everything. And so probably the more plausible explanation is he just didn't remember it at the moment, or didn't bring it up, didn't think it was important, or it left his mind at the time. But because he chose to make the statement, the prosecutor was able to say, look at that, he's lying now, and he made it up for trial. So just another one on the giant pile of countless real-world examples why you should never, ever, ever speak to the cops.
Yeah, don't let this be you, right?
Please don't. I mean, how many times do we have to say this? And how many real-world examples do we need to point to before people will start shutting up? Even good Samaritans, even people acting within the law.
Absolutely. So now Penny did say some good things, right? Most of his interview was good, really laid out the foundation of why he was scared, why he used the force he did. He described Neely as talking gibberish, screaming. He said that two other guys were trying to help him because he was still going nuts, even though he was restraining him. He talked about how he was not trying to kill the guy, just de-escalate the situation. He was trying to protect the women and children on the train, right? So he definitely, in the interview, more harped on defense of third parties and not self, but said a lot of good things, right? It described what was going on. He said that he felt like 100% somebody's life was in danger. Mm-hmm. And he was saying that he was squirming the entire time that he was giving the chokehold. The officer stated, "You think that you used too much force?" And he said, "No, I thought that that was enough to restrain him because he was still squirming even though I was holding him. And that's why two other people came to help me as well."
Yeah, the fear there is that if we let him go, he's going to make good on his threats that he just made. We have every reason to think that as soon as he's released, he'll continue to try to make good on those threats that he promised to carry out at the time that I restrained him. And I want to use that to kind of play devil's advocate a little bit here, because the prosecutor, remember, they have to show that the amount of force used by Mr. Penny was unreasonable given the circumstances. And the defense's case was that he was using the chokehold in order to protect the third parties from the legitimate threats that Neely had made on the subway car. So even the prosecutor conceded at trial that they don't fault Mr. Penny from the initial restraining of him. Okay, we're not going to try to beat him up too bad for initially restraining the guy. But by holding on to his neck for 6 minutes, that exceeded the reasonableness threshold and unnecessarily and unreasonably caused his death. And if I was the prosecutor trying to make this point, the main thing that I would point to is those two other folks who seem to be either assisting Penny with restraining Neely or standing close by watching, ready to intervene at a moment's notice, right? You see the videos, you can see Mr. Penny has Mr. Neely Neely on the ground. There's a gentleman who's holding Mr. Neely's hands, trying to keep them from thrashing around. First of all, why is he not charged, right? If the whole idea here is that we're restraining him, unreasonably causing his death, not sure why only Mr. Penny's charged under this state's same theory. Of course, I think charges for either of these guys would be ridiculous at this point. But under the same logic, you could charge the other guy as a conspirator in this death. But I digress. So he's helping control the hands to keep them from thrashing around. There's another man who's kind of standing over it. He looks like he's ready to go. If Mr. Neely were to get out of this chokehold, the cavalry has arrived for Mr. Penny. There's other people here that are assisting. So if I was the prosecutor in the case, as much as it sounds disgusting to me to work for Alvin Bragg in that office, if I was a prosecutor in that case, I would really focus on the third parties who are standing there assisting Mr. Penny, and here's the reason why. You have to show that the force, in order to get that conviction, you got to show that the force that he used was unreasonable. It exceeded the reasonableness threshold. And my argument as the prosecutor would be, okay, while it was initially appropriate to put him in the chokehold, as soon as the cavalry arrives and starts helping him, the amount of force necessary to protect third parties and engage in self-defense at that point dramatically decreases. Now you need way less force in order to reasonably constrain him. So if he had let up on the chokehold a little bit, for example, because the guy is now, Neely is now outnumbered, the amount of force that Penny needs to use dramatically decreases. He could have let up on that chokehold. He had two other people helping to restrain him. He didn't need to hold him in that chokehold anymore as soon as the others showed up. That would have been my argument as the prosecutor.
Also, to kind of go off of that, is that the police did highlight or question Penny about his background as a Marine, right? They talked about the chokehold, if that was a chokehold that he learned in the Marines, or if he does jujitsu or anything like that, because, you know, it's a reasonable person and their strength, right? When we talk about the legal analysis. And they were really questioning Neely about his background as a Marine to see if he used too much force because he's not a, you know, average citizen and, you know, stuff like that. So that also went into his chokehold as well.
So this case had kind of a dramatic ending, full of several curious twists and turns that I think that we should at least mention. After the case was submitted to the jury, they went back to deliberations asking the question, was the amount of force that Daniel Penny used reasonable, or did the state prove beyond a reasonable doubt that it was not reasonable to use this, and so therefore he was either reckless and caused the death or negligent and caused the death. So they were sent back with these jury instructions. They were looking over everything. And after several days of deliberation, they came back and they told the judge, we're gridlocked on count one. We're gridlocked on the reckless death, the manslaughter 2, and therefore we can't make a decision. And the judge gave them what's called an Allen charge, which is totally standard in a trial. That's just a order to the judge, hey, you guys, I'm encouraging you to go back and keep an open mind and try to work it out, because it's really important for juries to come up with a binding verdict in these cases. So it's basically a little instruction that the court gives them to encourage them to go back and give it another go. Very standard in these types of gridlocks. The court did that. The jury went back. They deliberated for a while longer, and they came back a second time and said, Judge, we are gridlocked on the manslaughter, on the count one specifically. Now, here's where it got interesting. When that happened, the state said, all right, Judge, well then what the state will do is we will file a motion to dismiss the manslaughter charge, and we're requesting the court send them back and get them to deliberate again on the lesser included, the negligent homicide. This is really, really odd, because normally what would happen when they hit a gridlock is that's going to be a mistrial. They're going to say basically, sorry, that's a mistrial. The state can choose to charge it again if they want within the statute of limitations, but the jury's telling us they can't make a decision. The state's rationale here was basically saying, hey, Judge, they only told you that they're deadlocked on count one. We don't know what their opinion is on the lesser included negligent, so why don't we make it easy for them to try to get that answer from them, dismiss count one, and you can point them back and tell them to go and deliberate again on count two. And of course, as they should have, the defense objected.
Good defense counsel.
Absolutely. They preserved the argument. They said, no, Judge, this should be a mistrial. You should throw the whole thing out at this point, because by sending them back and pointing to that second count, it is unduly coercive of the court. The court is basically implying that, okay, you guys are close to the right answer here. We want you to go back and really take a close look at that second count and see what you think about that. And they argued that this is unduly coercive. The argument here from the defense is, Judge, they've been considering both counts the whole time in deliberations. They could have come back and they could have convicted on the negligent homicide at any time during this whole thing. So they have been considering both of the counts the entire time. So by allowing the state to voluntarily dismiss the more serious one and pointing them to go back to really think hard about the second one is unduly coercive. They made a really good oral argument on the record on it. Ultimately, the judge said, I'll take the risk. He actually said that. I'm going to chance it. I'm going to risk it and send it back. And I'm going to tell them to go back and think about negligent homicide. This happened on a Friday afternoon, so the idea was they were going to take a break for the weekend, come back the following Monday, and go back to the jury room on the judge's order to consider the negligent homicide.
And they did come back on Monday with a not guilty verdict. So it did end in Penny's favor. Like we said, it could have been a really good appellate issue if they found him guilty on that lesser included, but they did find him not guilty, which is better for him in this case, right? Because double jeopardy attaches, which means they cannot re-bring the charges within the statute of limitations, which they could have done if they considered it a full mistrial.
Great point. All right, I said we weren't social commentators, but I think there's something to be said about how race managed to infuse itself through all of the proceedings as it has become the kind of issue du jour on every single high-profile case. Race needs to be talked about for some reason. Race, racy, racist, everybody's racist. This was clearly just a white man, killing a black man needlessly, and it would have been totally different if the races were reversed, say the critics. This is not our role as criminal defense attorneys. Our role as criminal defense attorneys is to look at what the evidence is, what the facts are, and apply what the standards of the law are. It's actually crazy how much I have seen even attorneys, even criminal defense attorneys in that jurisdiction talking about this case. I remember there was one that you and I saw that our jaws were on the floor.
Yeah, and we could even put that in the video.
So we have a white man who sneaks up behind a black man who is scaring other white people, kills that black man, and now is being tried by an almost entirely white jury. My thought on that is this is the story of America repeated over and over and over again.
But it basically said, innocent black man on the train, white man sneaks up on him, kills black man, and now white man is, on trial also with a white jury. Story of America still in 2024. And I just take issue with that, right? Because he was the aggressor, right? The alleged victim in this case was clearly the aggressor. Race had nothing to do with it, right? There was no racial motivated charges that, ensued with this prosecution. It was all just the facts of the case, and race was not included in those facts. And so to see a, member of the bar talk in that light about the situation, I don't know if he didn't watch the video or if he just saw other articles and went with it, but that's just not what happened, and it just really ignites the public.
Yeah, one of the things he said was this was a black man scaring white people. Did he not watch any of the body cameras with the numerous minorities, people of color walking up to the cops saying that guy's a hero, that guy didn't do anything wrong, I'm glad Mr. Penny did what he did because we were all in fear for our lives? Are those the white people that the black man is scaring? It's a ridiculous statement. And the point that you made about the prosecution itself not having an additional enhancement for race motivation is so relevant here. Because, trust me, if the prosecutor would have seen any reason to bring an enhancement for there being a race motivation, they certainly do. They certainly would have seized upon that. So the takeaway here is not even the prosecutor agrees that this was racially motivated or that there is any evidence whatsoever to present to the jury that this had a racial motivation.
Yeah, and I'm sure it's just clickbait, right? Everybody uses that as clickbait, but it's frustrating from the legal side to be like, that's not part of the legal analysis, right? People have an opinion on this case just based on headlines or, badly written articles. And so, I just always want to educate people before they make up their mind and talk about the facts of the case because it's all just clickbait.
Yeah, I'll mention something on the clickbait topic. I think that this issue is not nearly as big as people think that it is, and I think our media is to blame for magnifying this. I don't think that as many people are claiming racism as the media makes it out to be. Case in point, outside of the courthouse, there were these Black Lives Matter protesters. By all reports that I've seen, there were usually somewhere between 1 or 2 dozen. At max, there was about 3 dozen out there, according to various reporting, but usually it was between 1 and 2 dozen. The city of New York is the most populous city in the United States with 8.2 million people living there. So the fact that there was usually on average between 1 and 2 dozen people outside who were really, really upset and even talking about burning down the city and things like that is a very, very, very statistically insignificant part of the population of New York and of the country as a whole. There was a time, maybe fairly recently, where this was a large, significant portion of people had this mentality. This is a dying ideology. This is in its death throes. That is obvious here from this acquittal in an extremely liberal jurisdiction. This is obvious by the massive lack of support that these people have. And the problem here is that both sides of the political spectrum, the left and the right, are magnifying these idiots, these morons, these shameful grifters who are trying to divide us rather than promote a civilized society. It is shameful. Everybody who is out there yelling racism when there is no evidence of racism doesn't realize that they are hurting the victims of true racism. True racism exists. And when you cry wolf this many times and this loudly, where racism doesn't exist, you're just going to sap the credibility of real victims of racism. These people should be ashamed of themselves. And the fact that Fox News is showing them as if it's a real problem is just as big of a problem.
Like you said, it's just trying to divide, right? That's at the end of the day, that's what they're trying to do.
Yeah, I think that it's important to talk about the upcoming civil litigation because people, I'm sure, want to hear from Mr. Penny at this point and want him to hit the talk show circuit or the podcast circuit or give his story. I hope that his attorneys are strongly advising him not to do that at this point because there's some civil litigation pending here.
Yeah, and of course, a not guilty verdict will help in the civil case, but they have a different burden of proof, right? Criminal is beyond a reasonable doubt, and civil is preponderance of the evidence. In law school, they call preponderance of the evidence to kind of showcase that to law students is like 50% plus 1 feather, right? Just a tiny feather, and that's all that you need. So often you'll see, a not guilty or, something like that in criminal side, but still could have civil liability.
Mm-hmm. Absolutely, and it's being brought by Jordan Neely's family. I think his father is at the forefront of this civil suit. What are your thoughts on the civil suit, Britt?
I'm not a civil attorney, right? But I do think that it's sad that we often see people who need help, maybe from family members, and them not be there, right? We know he was homeless. We know he was on drugs. Now, we don't know the family situation. Maybe his family was trying to help him, and maybe he denied help or something like that. But then all of a sudden they're opening up, their pockets when something happens to him. So I just get a little disheartened by these big civil lawsuits because if he was homeless and where was the family? But now they're here, right? When they can maybe, get some money. So I don't know, but that's kind of my view.
We don't know all the circumstances. There are certainly a lot of people saying this looks really opportunistic where, this is a guy living on the street and 42 convictions and schizophrenia and in and out of the system over and over and over again and using drugs.
And he was in foster care, so he didn't have parents at one point, right?
Right.
And now he has a family member bringing lawsuit.
They want a few $1,000,000, for their pain and suffering and loss of consortium. So all of this analysis that I'm giving is actually relevant legally to what the consortium was, right? The idea is that you're suing for money damages, and you have to assess what would reasonable loss of consortium be. And if you have no relationship with the person whatsoever, then the answer to that is somewhere around $0.00. So in addition to liability here, which as you correctly pointed out is definitely improved for Mr. Penny's defense following the acquittal, there's also a question of damages, where even if there is liability, does the father, who may not have much of a relationship with the deceased, does he even have any damages or loss of consortium reasonably to claim? So we're not civil attorneys, but I think it's really important that Mr. Penny maintain silence right now on all substantive matters in the issue, given that there's pending civil litigation.
Yeah, absolutely.
All right, we'll keep an eye on this case, and if there are any more cool developments, we'll come back and chat about them. How's that sound?
That sounds good.
All right, everybody, thanks for tuning in today. Go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. Also, go check out attorneysforfreedom.com to learn all about our law firm and how we defend people in the criminal justice system. And if you enjoyed this video, make sure to leave us a comment down below, like the video, subscribe to the channel, share it with a friend. Until next time, this has been attorneys Andy Marcantel and Brittany LaBerry signing out. Peace.